I was standing on my back porch at 6 in the morning, coffee in hand, when I watched the white HOA maintenance truck cut straight through my south pasture for the third time that week. The driver did not even glance my way as the vehicle carved fresh ruts through the grassland I had spent 2 years restoring after the drought. My name is Zachary Xander, and I own a 200-acre cattle ranch in Gillespie County, Texas, about 15 miles outside of Fredericksburg. I bought this property 5 years ago when I left my corporate job in Houston, looking for a quieter life raising grass-fed beef. What I did not anticipate was that the neighboring Hillside Meadows housing development would treat my land like their personal shortcut. The problem started about 8 months ago when the Hillside Meadows HOA board decided to upgrade their community amenities. They built a new pool house, tennis courts, and a fancy clubhouse on the eastern edge of their property, which happened to border my ranch. The main entrance to their development was on the north side, a good 1.5-mile drive around the perimeter to reach their new construction area. My ranch sat directly between their main entrance and the construction zone. Some genius on their crew realized they could save 15 minutes by cutting straight across my land instead of driving around. At first, it was just once or twice. Then it became daily. Now it was multiple times per day. I had asked them nicely to stop. I had called the property management company. I had even attended one of their board meetings to explain that they were damaging my pasture, disturbing my cattle, and trespassing on private property. The board president, a woman named Patricia Winters who spoke with the kind of condescension that could curdle milk, told me I was being unreasonable. She said it was just a little shortcut, and that I had plenty of land, so what did it matter? She actually suggested I should feel honored to contribute to the community improvement. That morning, watching the truck disappear over the hill toward the HOA property, I made a decision. If they wanted to use my land, they were going to pay for it. Every single trip. I spent that entire day making phone calls. First, I called my attorney, Marcus Brennan, who I had used for the property purchase and various ranch business matters. He was a straight-talking guy in his 50s who had grown up on a ranch himself before going to law school. "They are doing what now?" Marcus asked when I explained the situation. "Cutting across my south pasture like it is a public road. Multiple times a day, I have asked them to stop. They will not." "How long has this been going on?" 8 months, give or take. Probably 5 to 6 trips per day on average, sometimes more during their peak construction times. Marcus let out a low whistle. "That is a lot of trespassing. You could pursue criminal trespass charges, but that gets messy and takes time. What exactly do you want to do?" "I want to charge them." "I looked into it, and I have the right to grant easement access across my property for a fee, correct?" "You do, but they would have to agree to it." "What if I send them a bill for retroactive usage?" Marcus was quiet for a moment, and I could hear him typing. "That is trickier. You cannot unilaterally impose a fee for something they are already doing illegally. However, here is what you can do. You can document everything going forward. Set up cameras, count every trip, and then you can pursue damages in civil court for the trespass. You would need to prove actual damages, though, which might be difficult. What about gates? Can I install gates across the areas they are using? Absolutely. It is your property. You can fence and gate it however you want. If they cut locks or break through gates, that is criminal mischief and possibly burglary of a vehicle if they are opening gates to pass through. That carries serious penalties. So, if I install gates, document when they open them, I can charge them for unauthorized use. Not exactly charge them, but you can sue for damages. Each unauthorized entry is a separate trespass. In Texas, You can sue for actual damages plus up to $1,000 per trespass in statutory damages. If you can prove they did it willfully after being warned, you might get more. My mind was already working through the logistics. What if I sent them a formal notice offering them an easement agreement with a fee structure? Then if they refuse and keep trespassing, I have proof they knew they needed permission and chose to ignore it. Marcus laughed. Now you are thinking like a lawyer. Yes, that would strengthen your case considerably. Send them a certified letter offering a legal easement agreement at a reasonable rate. When they decline or ignore it and continue trespassing, you have clear evidence of willful trespass. Just make sure your rates are defensible. Do not charge $10,000 per trip, or a judge will laugh you out of court. We spent another hour discussing the specifics. Marcus agreed to draft a formal easement offer letter and help me document everything properly. By the time I hung up, I had a plan. The next 2 days were busy. I contacted a security company and had them install 6 high-definition cameras covering the 2 main routes the HOA vehicles used across my property. The cameras were motion-activated and time-stamped, storing footage to a cloud server. I also hired a fencing crew to install 2 heavy-duty steel gates across the paths. These were not cheap farm gates. These were proper commercial gates with reinforced locks, designed to make it very clear that this was private property, and you needed permission to pass. While the crews worked, I researched what reasonable fees might be. I found that pipeline companies typically paid landowners anywhere from $500 to several $1,000s per year for easements, depending on the size and usage. Some commercial operations paid per vehicle fees. After consulting with Marcus, we settled on a fee structure of $75 per vehicle per trip for their maintenance trucks, and a flat fee of $5,000 per year for an official easement that would allow up to 3 trips per day. It was high enough to compensate me for the damage and inconvenience, but not so outrageous that a court would reject it. Marcus drafted a formal letter explaining that the HOA had been trespassing, outlining the damage to my property, and offering them the easement agreement as a legal alternative. The letter gave them 10 business days to respond and made it clear that any further trespassing after the gates were installed would result in legal action. We sent it certified mail to the HOA board, the property management company, and the construction company they had hired. The gates went up on a Wednesday. They looked impressive, stretching 12 feet wide across each path, with large private property no trespassing signs bolted to them. I felt a small sense of satisfaction as the installation crew packed up their tools. Thursday morning, my camera system sent me an alert at 7:15. I pulled up the app on my phone and watched in real time as an HOA maintenance truck pulled up to the southern gate. The driver, a guy in his 20s wearing an HOA polo shirt, got out and stared at the gate for a solid minute. He walked up to it, tested the lock, then pulled out his phone. I could see him talking animatedly. After about 5 minutes, he got back in his truck and drove away. The camera showed him taking the long route around my property. I allowed myself a small victory coffee. It lasted exactly 4 hours. At 11:30, another alert. This time, 2 trucks approached the southern gate. One was the maintenance truck from earlier. The other was a white Ford F-250 with Hillside Meadows HOA emblazoned on the side. A woman got out of the F-250, and even through the camera footage, I could see the fury in her body language. She marched up to my gate, tried the lock, then actually kicked the gate. When it did not budge, she threw her hands up and appeared to be yelling, though the cameras did not have audio at that distance. The woman pulled out her phone, and 2 minutes later my phone rang. Unknown number with a Fredericksburg area code. I answered. "Hello, is this Zachary Xander?" The voice was sharp, entitled, exactly what I expected. "Yes, this is Zach. Who am I speaking with?" "This is Deborah Fletcher, Vice President of the Hillside Meadows HOA Board. What is the meaning of these gates you have put across our access route?" "Our access route?" The audacity was almost impressive. "Those gates are on my private property, Miss Fletcher. They are there to prevent trespassing." "Trespassing? We have been using that route for months. You cannot just suddenly block it." "Actually, I can." "You have been trespassing on my land for months without permission. I sent a formal letter to your board earlier this week explaining this." "I do not know anything about a letter. You need to remove these gates immediately." "We have work to do, and we cannot waste time driving all the way around your property." I took a slow sip of my coffee, watching her on the camera as she paced in front of the gate. "Miss Fletcher, you should check with your board president about the letter. It was sent certified mail. In it, you will find an offer for a legal easement agreement at a very reasonable rate. If you want access across my land, you are welcome to sign the agreement and pay the fee." "Pay? You expect us to pay you so we can drive across some empty field?" "It is not an empty field. It is a working cattle ranch, and your vehicles have been damaging the pasture and disturbing my livestock. Yes, if you want to use my private property for your convenience, you need to pay for that privilege. Just like I would have to pay if I wanted to use your HOA facilities." "This is ridiculous. I am calling the sheriff." "Please do. I will be happy to show them the documentation of your repeated trespassing and explain why I installed security gates on my own property." She hung up without another word. Through the camera, I watched her have what appeared to be a heated discussion with the truck driver, complete with aggressive hand gestures. Eventually, both vehicles turned around and took the long route. Over the next week, I received 17 more phone calls from various HOA board members, property management representatives, and even one from the construction foreman. Each call followed roughly the same script: outrage that I had blocked their route, demands that I remove the gates, refusal to even consider paying for an easement, and threats of various legal actions. I remained calm and polite on each call, explaining that they were welcome to use the legal route around my property or sign the easement agreement. The cameras captured 11 more attempts by HOA vehicles to access the gates. Each time, they found them locked and had to turn back. I meticulously logged every attempt, noting the date, time, vehicle, and any other relevant details. Marcus had provided me with a spreadsheet template for tracking everything. On the Friday of that first week, I was out repairing a section of fence on the north pasture when I heard an engine approaching. I turned to see Patricia Winters herself driving a silver Lexus SUV across the field, heading straight for me. She was not on one of the gate paths. She had apparently decided to just drive onto my property from a completely different direction. I set down my tools and waited. She pulled up about 20 feet away and got out. Patricia was in her late 40s, with carefully highlighted blonde hair, designer sunglasses, and an expression that suggested she had never heard the word no in her life. "Mr. Xander, we need to talk." She did not offer a handshake or any pleasantries. "Mrs. Winters, you are trespassing." She waved a hand dismissively. "Oh, stop with that nonsense. I came here to discuss this situation like reasonable adults. I am being completely reasonable. I sent your board a formal letter with a fair offer. You have chosen not to respond. That letter is absurd. $75 per trip. $5,000 per year. For what? Driving across a field. for using my private property for your commercial purposes. Those are actually quite reasonable rates compared to standard easement fees." Patricia crossed her arms. "Let me be clear. Hillside Meadows is a valuable community development. We have over 200 homes, a $1 million clubhouse, and we bring significant property value to this area. Your little ranch benefits from our presence." "My ranch was here first, Mrs. Winters. And it does not benefit from your trucks tearing up my pasture and scaring my cattle." "Scaring your cattle? They are cows. They just stand around eating grass." I took a breath, reminding myself that losing my temper would not help. "Mrs. Winters, the law is very clear on this. You do not have permission to cross my property. I have offered you a legal way to obtain that permission. If you choose not to accept the offer, then your people need to use the public roads like everyone else. And if I simply instruct our crew to cut the locks on your little gates, then you would be committing criminal mischief, and I would press charges. I have cameras documenting everything, and I have already consulted with both my attorney and the sheriff's office about my rights." That made her pause. "You called the sheriff?" "I made an inquiry about property rights and trespassing law. They were very informative." Patricia stared at me for a long moment, her jaw tight. "You are making a big mistake. The HOA has lawyers too, and we have a lot more resources than some small-time rancher. We will bury you in legal fees." "That sounds like a threat, Mrs. Winters." "It is a promise. Remove the gates or we will sue you for interference with our business operations. You are welcome to try. My lawyer would be delighted to defend a property rights case. And when we countersue for 8 months of documented trespassing, the numbers might surprise you." She opened her mouth, closed it, then turned on her heel and got back in her Lexus. She spun the tires, pulling away, tearing up more of my grass in the process. I pulled out my phone and took several photos of the fresh tire tracks and the spot where her vehicle had entered my property from the HOA side. More documentation. That afternoon, Marcus called. "I just received a very entertaining letter from the Hillside Meadows HOA attorney. They are threatening to sue you for creating a private nuisance and interfering with their contractual business relationships. Patricia Winters paid me a visit today. She threatened me with lawyers and told me to remove the gates." "Did she now? Was this conversation recorded?" "No, but she drove her personal vehicle onto my property to do it. I have photos." Marcus chuckled. "These people are not very bright, are they? Okay, here is what we are going to do. I am going to respond to their attorney with a very detailed letter outlining every instance of documented trespassing, the damage assessments we have gathered, and our willingness to resolve this amicably through the easement agreement. I am also going to mention that their board president committed additional trespassing today and made what could be construed as threats. Let us see how they like that. You think they will actually sue? Probably not. Their attorney has to know they do not have a case. But people like this are used to bullying their way through problems. They figure if they threaten enough, you will fold. The question is whether they will fold first or if this has to go to court. I am prepared for court if necessary. I know you are. Let me handle the legal correspondence. You keep documenting everything and do not engage with any of them directly unless you have to. If Patricia or anyone from the HOA shows up on your property again, tell them to leave immediately and call me if they refuse." The weekend was quiet. No vehicles attempted the gates. I spent Saturday moving my cattle to the eastern pasture and Sunday going through all my camera footage, making sure my logs were accurate. I had documented 43 separate trespassing incidents by HOA vehicles since installing the cameras, not counting the hundreds that had occurred before I had video evidence. Monday morning brought a new development. At 8 a.m., a Gillespie County Sheriff's deputy pulled up my driveway. My stomach tightened. Had the HOA actually convinced law enforcement that I was doing something wrong? The deputy was a guy in his 30s named Officer Raymond Calhoun. He was polite and professional as I walked out to meet him. "Morning, sir. Are you Zachary Xander?" "Yes, officer." "What can I do for you?" "I received a complaint from the Hillside Meadows HOA claiming that you have illegally blocked a public right-of-way across your property. I am here to investigate the complaint." I felt relief wash over me. This I could handle. "Officer, there is no public right-of-way across my property. Would you like to see my deed and property survey?" "Yes, please." I invited him inside and pulled out my property documents. The deed clearly showed that I owned the entire parcel, with no easements or rights-of-way granted to anyone. The survey map showed the exact boundaries. Officer Calhoun studied the documents carefully. "So the HOA has been crossing your land without permission?" "For 8 months, yes. Multiple times per day. I asked them repeatedly to stop. They refused. So I installed gates and security cameras and offered them a legal easement agreement for a fee. They declined and have been calling me demanding I remove the gates." "And these gates are entirely on your property?" "Yes, sir. I can show you on the survey exactly where they are placed." I made sure they were well within my boundaries. The deputy nodded slowly. "Sir, I have to tell you, this is a civil matter, not a criminal one, unless someone damages your gates or continues trespassing after being properly warned. Have you sent them formal trespass warnings?" My attorney sent them a certified letter explaining they were trespassing and offering the easement agreement. They signed for it 10 days ago. "You have proof of that?" I pulled up the certified mail receipt on my laptop, showing the signature confirmation. Officer Calhoun took note of it. "Okay, Mr. Xander. Based on what you have shown me, you have every right to gate your property and deny access. The HOA does not have any legal right to cross your land without your permission. If they continue to trespass after receiving formal notice, that becomes criminal trespass and you can press charges. If they damage your gates or locks, that is criminal mischief. In either case, call us and we will respond." "Thank you, officer. I appreciate you taking the time to check it out." "No problem. Between you and me, HOAs can be a pain in the neck. I have dealt with Hillside Meadows before on various complaints. They tend to think their rules apply to everyone." He handed me his card. "If you have any trouble, give me a call directly." After Officer Calhoun left, I felt significantly better. The sheriff's office had confirmed what I already knew. I was in the right. I called Marcus and updated him. "Perfect," Marcus said. "That is exactly what we needed. Now they cannot claim they did not know they were trespassing or that law enforcement sided with them. Keep that officer's card and his report number. It will be useful." Tuesday morning, I was checking the cattle water troughs when my phone exploded with alerts. I pulled it out to see multiple camera notifications within seconds of each other. I opened the app and felt my blood pressure spike. At the southern gate, 3 HOA maintenance workers were cutting through the lock with bolt cutters. I immediately called 911, then started recording on my phone as I jumped in my truck and headed that direction. The dispatcher confirmed they were sending a deputy as I explained what was happening. By the time I got to the gate, they had cut the lock and were swinging the gate open. One of their trucks was already driving through. I pulled my truck across the path and got out. "Stop right there. You are trespassing and you just committed criminal mischief by destroying my lock." The 3 workers, all men in their 20s and 30s, looked at each other uncertainly. One of them, a stocky guy with a beard, stepped forward. "We were told to get through here no matter what. The HOA board said you cannot stop us." "The HOA board lied to you. This is private property. You just committed a crime and the sheriff is on the way. Another worker, younger and nervous-looking, pulled out his phone. I am calling my supervisor. Good idea. You should also consider getting your own attorney because destruction of property is a serious charge. The bearded guy puffed up. Look, man, we are just doing our jobs. We were told this was okay. Following illegal orders does not make it legal. You should have questioned your boss when he told you to cut locks on someone else's property. The younger worker was talking rapidly into his phone, his voice high with stress. Yeah, he says the cops are coming. What do we do? No, he is right here. I do not know, man. This seems really bad. Officer Calhoun arrived within 10 minutes, along with another deputy I did not recognize. I showed them the camera footage of the workers cutting the lock, the damaged lock itself, and the open gate. The workers admitted to cutting the lock when questioned, explaining that they had been instructed to do so by their HOA supervisor. Who specifically told you to do this? Officer Calhoun asked. The bearded worker hesitated, then said, Deborah Fletcher. She is the vice president of the HOA board. She said Mr. Xander was illegally blocking access, and we should remove the lock and use the route like normal. Officer Calhoun looked at me. Do you want to press charges? Yes, absolutely. For all three of them for criminal mischief, and I want charges brought against Deborah Fletcher for instructing them to do it. The deputy nodded. That is conspiracy to commit criminal mischief. We will need to bring Miss Fletcher in for questioning. The three workers were cited and released with a court date. Officer Calhoun explained that because it was a first offense and relatively minor damage, they would not be arrested on the spot, but they would have to appear before a judge. The officers went to find Deborah Fletcher while I replaced the lock with an even heavier one I had bought as a backup. That evening, Marcus called me with barely contained glee in his voice. Zach, you are not going to believe this. Deborah Fletcher was just arrested for conspiracy to commit criminal mischief. She apparently got very belligerent with the deputies when they questioned her, started yelling about how you should be the one arrested, and even pushed one of the officers. They added resisting arrest and assault on a peace officer to her charges. You are kidding. I am not. It gets better. The story is already spreading around town. Several HOA residents have called the local news station to complain about the board's behavior. Apparently, a lot of the homeowners in Hillside Meadows are fed up with how aggressive and high-handed the board has been about various issues. This might be the tipping point. Wednesday morning, a reporter from the Fredericksburg Standard Radio Post called asking for an interview. I agreed, figuring public attention might help my case. The reporter, a sharp woman named Jennifer Cole, came out to the ranch that afternoon with a photographer. I showed her the damaged gate, explained the months of trespassing, showed her the ruts and damage to my pasture, and walked her through my attempts to resolve the issue peacefully. She took extensive notes and photos. This is a great story, Jennifer said. Property rights, HOA overreach, and now criminal charges. Do you mind if I reach out to the HOA for their side? Not at all. I have documentation for everything I have told you. The article ran on Friday, both in print and online. The headline read, Local rancher battles HOA over repeated trespassing, board member arrested. It was fair and balanced, including quotes from Patricia Winters claiming I was being difficult and unreasonable, and that the HOA was exploring all legal options. But the article also included the fact that Deborah Fletcher had been arrested, that deputies had confirmed I had every right to gate my property, and quotes from several Hillside Meadows residents expressing frustration with their HOA board. The online version went viral locally. Within 24 hours, It had hundreds of shares and comments, most of them supporting me. Several people shared their own HOA horror stories. A few defended the HOA, but they were in the minority. By Monday, the pressure had apparently become too much. Marcus called me mid-morning with news. The HOA's attorney just contacted me. They want to negotiate a settlement. What kind of settlement? They are willing to pay for the damage to your pasture and sign the easement agreement with some modifications to the terms. What modifications? They want the per-trip fee reduced to $50 and the annual easement option reduced to $3,000 per year. They also want the right to make up to 5 trips per day under the annual plan instead of 3. I thought about it. $50 per trip was still reasonable, and if they were making 5 trips per day, the annual plan at $3,000 was actually a worse deal for them than paying per trip, unless they were planning to use it even more frequently. Tell them I will agree to $50 per trip and $4,000 per year for up to 5 trips daily, and they pay for all damages to date, plus my legal fees and replacement of the lock their people destroyed. I will present that. What about the criminal charges against their board member? Those are separate. I am not dropping those as part of any civil settlement, Marcus laughed. I like the way you think. Let me get back to them. 2 hours later, Marcus called back. They agreed, all of it. They will pay $12,000 for assessed damages to your pasture, $3,000 for your legal fees to date, $200 for the lock, and they will sign a 5-year easement agreement at $4,000 per year. The easement allows them up to 5 trips per day, and any trips beyond that are billed at $50 each. Do we have this in writing? I am drafting the settlement agreement now. They are motivated to close this quickly because the publicity has been brutal for them. Apparently, there is a movement among the homeowners to recall the entire board. Good. They earned it. The settlement was finalized by the end of the week. The HOA's insurance paid the damages and legal fees, and their attorney delivered a certified check along with the signed easement agreement. I provided them with keys to the gates and codes for the new electronic locks I had installed. The following Monday, I watched on my cameras as an HOA maintenance truck approached the southern gate. The driver got out, used the code to unlock the gate, drove through, then got out again and properly closed and locked the gate behind him. He followed the designated path across my property, staying on the route we had specified in the easement agreement, and caused minimal disturbance to the pasture. I logged the trip in my spreadsheet and noted that they were in compliance with the agreement. Deborah Fletcher's criminal case moved forward. She pleaded no contest to conspiracy to commit criminal mischief and paid a fine. The assault and resisting arrest charges were dropped as part of a plea deal. She also resigned from the HOA board under pressure from the homeowners. Patricia Winters lasted another month before the homeowner recall petition succeeded. She was removed as board president along with 2 other board members who had supported her aggressive tactics. The new board was a group of more reasonable people who actually seemed interested in working with neighbors rather than bulldozing over them. In total, over the course of that year, the HOA made an average of 4 trips per day across my property under the easement agreement, which worked out well for both parties. I received my $4,000 annual payment on time, and they saved time on their construction and maintenance routes. When they occasionally needed a 6th or 7th trip in a day, I would receive the per-trip billing, which they paid without complaint. The damaged areas of my pasture recovered over the following growing season. I reseeded the worst sections and kept my cattle off them until the grass was well established. By the next spring, you could barely tell there had been any damage. The story had a few interesting ripples beyond my immediate situation. The Fredericksburg Standard's article was picked up by a few larger Texas newspapers, and I was contacted by 2 other landowners in similar situations with HOAs or commercial neighbors. I shared my experience and Marcus's contact information with them. One case settled quickly after the landowner followed my template of documentation and formal easement offers. The other went to court, but the landowner won based partially on precedent from my case. The Hillside Meadows HOA itself underwent significant reforms. The new board implemented more transparent procedures, created a community advisory committee, and actually started treating their neighbors, including me, with respect. They invited me to a community barbecue that summer, which I attended. Several homeowners apologized for the previous board's behavior and thanked me for standing up to them. I even developed a cordial relationship with the new board president, Michael Garrett, who owned a small software company and understood business relationships. When a water line issue affected both my property and the HOA land that winter, we worked together to solve it efficiently and split the costs fairly. The construction company finished their work on the HOA facilities by late fall. The crew foreman, a guy named Tom who I had talked to several times during the dispute, stopped by the ranch before they demobilized from the project. He brought me a bottle of decent whiskey and apologized for his company's role in the mess. "I told the HOA from the start that cutting across your land without permission was wrong," Tom said, "but they were the clients and my boss did not want to make waves. I am glad you stood your ground." "I appreciate that, Tom. No hard feelings. You were put in a bad position." Still, it was not right, and for what it is worth, that Deborah Fletcher was a piece of work. She tried to blame everything on our crew when the cops showed up, said we acted without authorization. Luckily, we had her instructions in writing. After Tom left, I sat on my porch with a glass of that whiskey and looked out over the south pasture. The sun was setting, painting the Texas hill country in shades of orange and gold. My cattle were grazing peacefully, undisturbed. The gates were closed and secured. My property was my own again, used only with permission and proper compensation. It had been a frustrating, exhausting battle, but worth it. Not just for the money, though the settlement and easement fees were nice. It was about the principle. About standing up for property rights, and not letting entitled people bulldoze over you just because they thought their convenience mattered more than your rights. I finished my whiskey and went inside to start dinner. Tomorrow I needed to check the fence line on the north pasture and maybe move some cattle. Regular ranch work, the kind of problems I had signed up for when I bought this place. Much better than dealing with trespassing HOA board members. The cameras sent me an alert around noon the next day. I checked my phone expecting to see an HOA vehicle, but instead, it was a television news van from San Antonio pulling up to the gate. I sighed. A reporter from a San Antonio station had called yesterday asking for an interview. I had agreed, figuring one more news story would not hurt, and it might help other people in similar situations. The reporter was an enthusiastic young guy named Brad Santos, who seemed genuinely interested in property rights issues. We did the interview by the gate, with me explaining the situation and showing the camera footage of various incidents. Brad was particularly interested in the broader implications. "You think this is a growing problem in Texas?" Brad asked. "HOAs overstepping their authority." "I think anytime you give a small group of people power over their neighbors, there is a risk of abuse," I said. "Most HOA boards are probably fine, just volunteers trying to keep their neighborhoods nice. But some boards, like the one I dealt with, start thinking they are above the rules that apply to everyone else. They need to be reminded that property rights and laws still apply, even to HOAs. The interview aired that evening on the San Antonio News. Marcus called me afterward, laughing. "You are becoming quite the property rights activist," he said. "I have had 3 calls today from people in HOA disputes who saw your interview and want help. Am I creating work for you? The best kind of work. Cases I can win. Keep it up." Life settled into a comfortable rhythm after that. Winter came to the hill country, mild by most standards but cold enough that I had to break ice on water troughs some mornings. The HOA used their easement regularly but respectfully, and their checks arrived on time. I focused on my cattle operation, which was actually having a good year. The grass-fed beef market was strong, and I had several standing orders from restaurants in Fredericksburg and even a few in Austin. In February, I attended Deborah Fletcher's final court hearing. The criminal charges had been reduced as part of her plea deal, but she still had to appear before the judge for sentencing on the conspiracy charge. I sat in the back of the courtroom and watched as she stood before Judge Harold Martinez. The judge was not particularly sympathetic. "Miss Fletcher, you held a position of responsibility in your community. Instead of respecting your neighbor's property rights and seeking a legal solution, you instructed employees to commit a crime. The only reason you are not facing more serious consequences is because you accepted responsibility and the damaged property was relatively minor. However, I want to make something very clear. HOA board membership does not place you above the law. You will pay the fine, and you will complete 20 hours of community service. If you find yourself before me again on any similar charges, the consequences will be much more severe." Deborah paid her fine and left quickly, not making eye contact with anyone. I felt a small sense of satisfaction, not from revenge but from accountability. She had broken the law and faced consequences. The system had worked. Spring brought new grass and wildflowers across the ranch. The bluebonnets were particularly stunning that year, covering whole sections of pasture in deep blue and purple. Tourists came from all over to photograph the wildflowers, and I allowed a few professional photographers access to some of my better viewing spots for a small fee. Another lesson learned from the HOA situation. People wanted to use my property. They could pay for it. The second year of the easement agreement arrived, and the HOA paid their $4,000 on time without any issues. Their new board had proven to be professional and easy to work with. When they needed to bring in some heavy equipment for pool repairs that spring, Michael Garrett called me personally to ask if the equipment would damage the pasture and offer to pay extra for any repairs needed. I appreciated the courtesy and told him we could evaluate after the work was done and settle up fairly. As it turned out, they stayed on the path and caused no damage, so no extra charges were needed. That summer, I was invited to speak at a Texas Farm Bureau meeting about property rights and dealing with encroaching development. Apparently, my situation had resonated with a lot of rural landowners who were facing similar pressures as urban areas expanded. I talked about the importance of documentation, knowing your rights, and getting good legal counsel. I also emphasized the value of trying to work things out reasonably first, but being prepared to stand your ground when necessary. After my talk, at least a dozen people came up to share their own stories. One rancher near Austin was dealing with a developer who wanted to run a water line across his property without compensation. Another farmer near San Marcos had a similar trespassing situation with a commercial neighbor. I shared Marcus's contact information with several of them and encouraged them to document everything. The speaking engagement led to a few more. Apparently, I had accidentally become something of a spokesperson for rural property rights in Central Texas. It was not something I had planned, but if my experience could help others avoid similar problems or give them the courage to stand up for their rights, I was happy to do it. By the third year of the easement agreement, my relationship with the Hillside Meadows HOA had evolved into something almost friendly. The new board occasionally consulted me on issues that might affect my property, and I did the same when I was planning anything that might impact them. When I decided to expand my fencing to create a new pasture rotation system, I made sure the design would not interfere with their easement route. That fall, Michael Garrett asked if I would be willing to host a community education event at my ranch. The HOA wanted to help their residents, especially the kids, understand where food came from and learn about sustainable agriculture. I agreed, and we organized a day where families from the development could come tour the ranch, learn about grass-fed beef production, and see how a working ranch operated. About 40 people showed up, mostly families with children. I gave them a tour, explained how rotational grazing worked, showed them how we processed and sold our beef, and answered dozens of questions. The kids were particularly interested in the cattle and loved getting to see the newborn calves. Several adults expressed surprise at how much work and planning went into raising beef sustainably. At the end of the day, Michael approached me with a thoughtful look. "You know, Zach, a few years ago, I never would have imagined our HOA having this kind of relationship with you. When I bought my house, all I heard were complaints about the difficult rancher who would not let anyone cross his land. And what do you think now?" I asked. "I think you were completely right, and the previous board were idiots who created a problem that never needed to exist. If they had approached you respectfully from the start and offered fair compensation, none of the conflict would have happened. Instead, they assumed they could bully you, and it backfired spectacularly. I appreciate you saying that, and I appreciate the way the new board has handled things. This easement arrangement works well for everyone." It does. And honestly, paying you $4,000 a year is cheaper than the legal fees from fighting with you would have been. Plus, we get a good relationship with a neighbor instead of an enemy. It was the smart business decision all along. We shook hands, and as I watched the families from Hillside Meadows drive away that evening, I reflected on how much had changed. The conflict that had consumed months of my life and significant stress had ultimately led to a better situation for everyone involved. The HOA had learned to respect property rights and work with neighbors. I had learned the value of documentation and standing firm on principles. And the community as a whole had seen a demonstration that even small landowners could stand up to larger organizations when they were in the right. The easement agreement continued for the full 5 years. When it came up for renewal, Michael and I negotiated a new 10-year agreement with adjusted terms to account for inflation and changing usage patterns. The HOA's construction was complete, so they needed less frequent access, but they wanted to keep the easement for occasional maintenance and access to their back facilities. We settled on a reduced annual fee of $2,000 for up to 2 trips per day, with a per-trip rate for anything beyond that over those years. I expanded my ranch operation, adding another 50 acres when an adjacent property came up for sale. I built a new barn, upgraded my water systems, and developed a small but loyal customer base for premium grass-fed beef. The ranch was profitable, sustainable, and exactly the life I had hoped for when I left Houston. The gates remained in place, well-maintained and properly locked. The cameras continued to record every vehicle that passed through, automatically logging the trips and helping me maintain accurate records for the easement agreement. The system had become routine, just another part of managing the ranch. I occasionally saw Deborah Fletcher around Fredericksburg. We never spoke, but I noticed she gave me a wide berth whenever we ended up in the same store or restaurant. Patricia Winters had moved away about a year after being recalled from the HOA board, reportedly to Arizona. I did not miss her. The 3 workers who had cut my lock that day all ended up paying small fines and doing community service. I saw one of them, the young, nervous guy, working at a feed store in town a few years later. He recognized me and came over to apologize again. "Mr. Xander, I just want to say I am really sorry about what happened. I was young and stupid and should have known better than to follow those instructions." "You learned a valuable lesson," I told him. "When someone tells you to do something that seems wrong, trust your instincts. Always question orders that involve breaking locks on someone else's property." He laughed nervously. "Yeah, I definitely learned that. Cost me $1,000 in fines and legal fees plus the embarrassment. But honestly, it could have been worse." The judge was pretty lenient since it was a first offense and we cooperated. "Well, I hope things are going better for you now." "They are, thank you. And for what it is worth, everyone I know thinks you handled that whole situation perfectly. The HOA was way out of line." Stories like that reminded me why standing up for my rights had been worthwhile. It was not just about me or my ranch. It was about setting a precedent, showing that property rights mattered, and that entitled people could not just steamroll over others because it was convenient. The legal community in Fredericksburg and the surrounding area had definitely taken notice. Marcus told me he had been consulted on at least a dozen similar cases over the years following my dispute, and most of them cited my case as precedent. Several had settled quickly when landowners followed the same approach. Document everything, send formal demand letters, install proper security, and be willing to go to court if necessary. The landowners won in almost every case. As I approached the 10th anniversary of buying the ranch, I found myself reflecting on everything that had happened. The HOA dispute, which had seemed so overwhelming at the time, was now just one chapter in a much larger story. Yes, it had been stressful and frustrating, but it had also taught me valuable lessons about standing firm on principles, the importance of good legal counsel, and the power of documentation. The south pasture, where all those trucks had torn up the grass in the early days, was now lush and healthy, indistinguishable from the rest of the ranch. The gates stood as permanent reminders of the importance of boundaries and respect. And my relationship with the Hillside Meadows community had evolved into something positive, built on mutual respect and fair dealing. One evening in late spring, I was sitting on my porch watching the sunset when Michael Garrett drove up. He had called earlier asking if he could stop by to discuss something. I invited him up to the porch and offered him a beer. "Thanks for seeing me, Zach. I wanted to talk to you about something before bringing it to the full board." "What is on your mind?" "Our easement agreement comes up for renewal again next year. We have been talking about the long-term future, and several board members have suggested that, instead of continuing to rent the easement from you, we should try to purchase a permanent right-of-way. What would you think about that?" I took a slow sip of my beer, considering. "What kind of terms are you thinking?" "We would want a 20-foot wide permanent easement along the route we currently use. We would pay you a one-time fee and then it would be recorded on both our deeds. You would still own the land, but we would have a legal right to cross it without annual payments." "And what would this one-time fee be?" Michael pulled out a folder with some papers. We had it appraised. "Based on the current fair market value and standard easement calculations, we are prepared to offer $30,000 for a permanent easement with reasonable usage terms." I studied the paperwork. 30,000 was actually a fair offer, probably even generous. But I was not sure I wanted to give up the ongoing easement income, and I definitely wanted to maintain some control over how my land was used. Can I be honest with you, Michael, please? I appreciate the offer, and it is a fair number, but I prefer the current arrangement. The annual easement gives me leverage to ensure you continue to use the land respectfully. If something changes, if you start abusing the access or causing damage, I have recourse through the lease terms. With a permanent easement, I would lose that control. Michael nodded thoughtfully. I understand that perspective. What if we included specific usage terms in the permanent easement? Things like maintenance responsibilities, limits on vehicle size and frequency, and penalties for damage. You could, but enforcing those terms would be harder with a permanent easement. Right now, if there is a problem, I can refuse to renew the lease. That gives both of us incentive to maintain a good relationship and honor the terms. That is a fair point. Michael leaned back in his chair. Okay, here is another thought. What if we extended the current easement to 20 years instead of 10? It would give us long-term certainty, but you would still have the ultimate control through the lease renewal at the end. I would be open to that, with appropriate escalation clauses for the fee adjustments over time. And I would want the same terms about usage, damage, and my right to access and manage the land. That sounds reasonable. Let me take that back to the board and see what they think. We shook hands and Michael left. I sat on the porch a while longer, thinking about the conversation. It was remarkable how different this negotiation felt compared to that first conflict years ago. Now we were working together, proposing solutions, treating each other with respect. That was how neighbor relations should work. The following month, Michael came back with a proposed 20-year easement agreement. The terms were fair, with the annual fee starting at $2,500 for the reduced usage they currently needed, with escalation clauses tied to inflation every 5 years. The agreement included detailed terms about maintenance, usage limits, and my rights to inspect and ensure compliance. Both parties could terminate with cause if the other violated the terms, but otherwise it would run the full 20 years. Marcus reviewed the agreement and pronounced it solid. This is actually a really good deal for you, Zach. 20 years of guaranteed income, proper escalation clauses, and you maintain control through the termination provisions. Plus, if they ever want to increase usage, you have provisions for renegotiating the fee. I signed the agreement, and so did the HOA board. We had a small signing ceremony at the ranch, with several board members and some interested homeowners attending. It was a far cry from the hostile confrontations of years past. As I watched the small crowd enjoying refreshments on my porch afterward, I thought about how the entire situation had played out. What started as a conflict over trespassing and disrespect had ultimately resulted in a fair business arrangement, improved community relations, and a template that had helped other landowners protect their rights. The gates still stood, and the cameras still recorded, but now they were just tools for managing a legitimate business relationship rather than weapons in a property rights battle. The HOA truck still crossed my land several times a week, but now with permission, respect, and proper compensation. Sometimes standing your ground and fighting for what is right leads to outcomes better than anyone could have predicted. The key is knowing your rights, documenting everything, getting good counsel, and never backing down when you are in the right. Those principles had served me well throughout this entire experience. Looking back, I would not change anything about how I handled the situation. Yes, it was stressful. Yes, it took time and money and effort. but it was worth it to establish that my property rights mattered, that I could not be bullied or intimidated, and that fair dealing was the only acceptable way forward. The ranch continued to thrive. My cattle operation expanded. The easement income provided a nice supplemental revenue stream. And my relationship with the Hillside Meadows community evolved into something genuinely positive. I even counted several of the homeowners as friends. Years later, when people asked me about the whole HOA situation, I would tell them it taught me one of the most important lessons of my life. When you know you are right, when you have the law on your side, and when your principles are sound, stand your ground. Do not let anyone bully you into giving up your rights just because they think their convenience matters more than your property. Document everything. Get good legal counsel. Be professional and calm. Make reasonable offers. But never, ever back down from defending what is rightfully yours. Those gates I installed all those years ago still swing open and closed several times a week. The locks are well maintained, the cameras still record, and the logs are meticulously kept. But now, they represent something different than they did in the beginning. They are not symbols of conflict anymore. They are symbols of respect, fair dealing, and the principle that property rights matter. Every time I see an HOA vehicle properly unlock the gate, drive respectfully through my pasture, and carefully lock the gate behind them, I feel a sense of satisfaction. Not because I won some petty battle, but because I established something bigger. The principle that neighbors should treat each other with respect, that property rights are fundamental, and that there is a right way and a wrong way to conduct yourself. The Hillside Meadows community learned that lesson the hard way, but to their credit, they learned it well. The current generation of board members and residents understand that they are part of a larger community, that their neighbors have rights that must be respected, and that fair dealing benefits everyone, and me. I learned that standing up for yourself, even against a larger organization with more resources, is not only possible but necessary. I learned the value of good legal counsel, proper documentation, and calm professionalism even in heated situations. Most importantly, I learned that principles matter and defending them is always worthwhile. The ranch continues to be everything I hoped for when I left Houston all those years ago. It is peaceful, productive, and mine. The land is healthy, the cattle are thriving, and my business is sustainable. The HOA situation, which once threatened to make my life miserable, ultimately made everything better by forcing clear boundaries and fair arrangements. As I finish my evening rounds and head inside for the night, I glance at the monitor showing the camera feeds. The gates are closed and locked. The pastures are quiet under the stars. Everything is as it should be. My land, my rules, properly respected and fairly compensated. That is how it always should have been. It just took some gates, some cameras, and the willingness to stand firm on principles to make it happen. And in the end, everyone benefited from learning that lesson.